Quillian. I'm here at Taylor English Duma with Litigation's Fundamentals with Henry Quillian. This is a training session within our litigation department as well as our employment, labor and employment group. We have a whole bunch of paralegals and attorneys here in the room with us, and we are here to discuss principles that can be utilized within your practice. We are not providing legal advice to you out there in the world, but we are providing you with information you can use to go to your own attorney in order to reach conclusions that you reach on your own regarding what to do with your litigation. It turns out that today is a restart of a process we started about 8 years ago, and we're starting today with how do you file a lawsuit in Georgia under the Civil Practice Act and the related rules. And what you learn is, within this segment, is that the rules are very important. Everything is rule driven, whether it be in a statute or whether it be in the Uniform Superior Court rules or the Uniform State Court rules. And we must acknowledge that the rules change and that we don't have perfect memories. So I have a mantra that I use within this session, which is that if you don't know what you need to do, you should read the rules. And within these sessions, if I say, so where do we go to find out the answer to this? Everybody should say,
go to
read the rules. And then the other mantra is, if you think you know everything, but it's been a long time since you've read the rules and you're about to do something, what should you do?
Read the rules.
Read the rules. And in fact, I find out every year that rules change and somebody is bringing to me some bit of information that the rules have changed in some material respect, and sometimes that results in the need to change something that I thought I had fixed in my mind as being perfectly sound, but it's actually wrong. And so it's always a good place to start to read the rules. And the words of the rules are important, and the way they've been interpreted by the courts is also important. Now today, we're going to talk about starting a lawsuit in Georgia. And for those of you out in the world, you don't have this hypothetical that I've distributed, but I'm going to read it to you because it's got a lot of little components that we can use in establishing how to start a lawsuit in Georgia. And so I'll just start off by this, and then we'll discuss this as a focal point throughout this discussion. But it won't be the only thing we discuss. We can also bring in other experiences, etc. So 5 years and 364 days ago, since Deadbeat Dan missed his payment on a note held by Solvent Sally, Sally comes into your office at 3 p.m. and tells you, I want to collect on this note. You're in a small town and your office is situated directly across the street from the Superior Court. Deadbeat Dan may, however, live just across the county line. But it's Friday and the clerk, you know, has a habit of leaving for the Friday night lights. What must you do? Wise lawyers might say to turn down the representation, but otherwise lawyers inform you to ask for a big cash retainer and to go for it. Though you've never filed a complaint before, the light bill is overdue and you've been sitting on your duff all month writing contracts, long awaiting your chance to be a real lawyer. This is your chance to represent Solvent Sally in court. Unfortunately, however, they did not teach you anything practical in law school, like how to start a lawsuit. So, you have maybe an hour to figure it out. You know that this is not a criminal matter, so it must be civil. John Travolta's movie, Civil Action, comes to mind. So you figure that that is what you need. Because the Superior Court is closest by, you want to file there. It's a court of record under OCGA 911-1, which is the beginning of the Civil Practice Act. All the answers you need are in the Civil Practice Act and in the Uniform Superior Court rules. Or at least that's what you thought. And that's something we'll address today. But you don't have law. So what do you do when you're in doubt? You read the rules. Okay. So we've already talked about the fact this is a civil action and we'd like to file in Superior Court. What if the note is only for $8,000? Can you file in Superior Court? Can you file in Superior Court? Why not?
It'd be 10,000.
There are other places where you could file. You could file in magistrate court, but it's not across the street. But can you file in Superior Court? I think you can. It's a civil action, and Superior Courts are courts of general jurisdiction in Georgia. It might be better to file in a magistrate court, but a lot of small counties don't have magistrate courts. And you've got this time crunch, right? So I think you can file in Superior Court. But for the sake of this case, let's just say it's a $100,000 note. So where would you go to determine what you need to do to file a lawsuit? If you've got 2 hours before the clerk office officially closes. You can go to the clerk's website. Who else might be involved with filing a lawsuit in the Superior Court of the small county court?
Clerk's office.
The clerk's office. You could call the clerk and say, hey, I know you like going to Friday Night Lights, but I may be coming in at the last minute and may need help getting this done. So there's nothing wrong with actually calling a person and establishing a human relationship with the person who you hope to have a long-standing relationship with as a paralegal or as a new lawyer. And you certainly don't want to find out the door is locked 5 minutes early when you're coming in 4 minutes before the deadline, because in 364 days and in 5 years and 364 days, what are we running across here with respect to this non-payment on the note? Statute of limitations. That's why our general counsel would say, refer to somebody else right away. Except everybody wants business, right? Insolvent Sally sounds like a good person to represent. So you might make your first call to the clerk. What else, if you wanted to start off that conversation well and you've got one defendant and you've got to file this thing with the clerk, what might you ask the clerk with respect to this lawsuit? If you get the clerk on the phone.
How much is the fee? How much is the fee?
Oh, what's the filing fee? Yes, we'll go into that, but yes, you know you're going to have money to get the lawsuit filed, and they're going to want to collect that money at the time that you're taking the lawsuit in. So you need to know what the filing fee is. And if you've never filed a lawsuit before, it can be different in various places, and so you want to make sure you have what you need in hand when you dash across the street at the very last minute to file this lawsuit, because you only got 2 hours to get the whole thing going. Okay, who can tell me what does it take to start or commence a civil action in the Superior Court in the courts of Georgia?
Civil cover sheet.
Civil cover sheets, one answer. Summons.
Complaint.
A complaint, yes.
Filing fee.
And the filing.
And a filing fee. Case initiation form. Aha! We may have hit upon something.
Is that the same thing as the
That's the
civil cover
same
sheet?
thing.
I don't know. Is it the same thing or is it not the same
Yes,
thing?
it is.
It is.
No.
Well, it can be or cannot be.
So it
What's
is
the
the
same?
One's in federal court.
So, we'll start off, however, with a complaint. Why? Because when you read the rules, it actually says OCJ 911.3, a civil action is commenced by filing a complaint with the court. It doesn't actually say it commenced upon the filing of civil action cover sheet or case initiation form. However, it does say in paragraph B that at the time of the filing of the complaint, the plaintiff shall file a civil action form, case filing form, with the clerk of court. Now, we get to, so what are these two things? We'll go into the complaint in a minute, but it seems like the most popular thing right now is a civil action filing form. Is that detailed in the Uniform Superior Court rules at this very moment? Properly. We had a no. That's because the Supreme Court, the legislature during last legislative session required a statute that required a different civil action case filing form, and it had to be approved by the Judicial Council of Georgia. And then the question is, where is it? How do you get it? When preparation for presentation on this earlier this year, we found the only place to find this was on the Supreme Court's website. And there was a press release that came out in November 2017, which alerted people to the fact that this would be coming. And then on the Supreme Court website is this special form that is now different from the previous forms that were available and allowed in the Superior Courts, and it's called a General Civil and Domestic Relations Case Filing Information Form. I would like to come up with the acronym for that. That's exactly what it is. But basically, this is a form that has the names of the parties, a number of boxes to check regarding what kind of case it is, who the plaintiff's attorney is, how many who's going to be involved in the case. But then it has, I think the reason why they changed it, it's got several special things down at the bottom, which are important to know. One is there a related action that this case you're filing is associated with? That would be a previous lawsuit between the same two parties, usually, that has the same subject matter. That's to help the court direct the case to the same judge if it's a related action. It's also got a very important one for paralegals to know, because if you check this box and you get it wrong, you're lying to the court. The lawyer is lying to the court. Lawyers don't like to find out after the fact they lied to the court. They don't like to do it in the first place. But it says, I hereby certify that the documents in this filing, including attachments and exhibits, satisfy the requirements for redaction of personal or confidential information in OCGA 911-7.1. So what if Deadbeat Dan had written his Social Security number on the note that you want to attach to the complaint? You would redact it. And this is a reminder that you need to redact that before you file it with the court. And you're certifying that you've done this. Now, it also asks, is there an interpreter needed for the case? And then it says what language? That's a new one. And then it also goes into, do you or your client have any disability accommodations or need any disability accommodation? I guess that's to alert the court as a whole. Are you going to need special things in connection with pursuit of this lawsuit? Anything to help you along the way? So it's brilliant that they've got this in here, because who had read the rule on redaction of personal information in the statutes before coming into this room? Yeah, we got a number of hands going up, thankfully, but we need to make sure that happens, because we're certifying. Now, the other thing you can think about is, who knows how we do a lot of filing these days? Electronic filing. So what if you're a brand new lawyer and all you've been doing is sitting on your duff reviewing contracts, and it's mandatory electronic filing at the Superior Court where you want to file a lawsuit? What else are you going to need to do in that 2 hours that you have to file a lawsuit? You would need to do everything that's necessary, including registering, right, with the with the filing system?
A lot of courts also, for people that aren't attorneys, will have a portal in the clerk's office to e-file at the clerk's office. So if he can't get his credentials right away, he can go over to the clerk's office and they would have to make it available to him.
Okay, so what I'm going to repeat so that everybody out there here, everybody in here, is that courts do make accommodations for people that are trying to electronically file and never have done it, never have registered, and need to do it. And I have seen pro se, I do know pro se people who are registered with respect to their individual lawsuit to do electronic filing. But that would be something you would want to ask the clerk about when you call over there, because they may have just instituted the filing system. They might have switched from one service provider to another. As far as I know, in Georgia, we now have 2 service providers. Now, if you do file something with electronically using this either of the electronic filing systems in Georgia, and there is a signature on the document, does anybody know what you're doing by filing the papers with a signature? You're inherently certifying that the signature on the document is authentic, which means you have to take that into account, because you don't want to go filing, you don't want to file somebody else's lawsuit until you verify that that is their signature or they approve the pleading that you're filing. This especially applies to paralegals. I don't think anybody at this firm wants a paralegal. If we were to, they may ask you, just file a complaint against so-and-so and get it going. Well, I think every attorney would want to see it and approve before their signature is applied and then also the case is filed. Because you are certifying that that is their signature, and essentially they've complied with all the Rule 8 requirements for signing. Okay, so we've got anybody that can read can fill out the civil case filing form, but you do have to know what meant by what the boxes that are checked. We talked about the complaint. What is a complaint? What does it have to have on it? The most basic things. The names of the parties. And generally you have a plaintiff, which in this hypothetical would be Silent Sally, and the defendant, who would be Deadbeat Dan. And if you're choosing the Superior Court of X county, what would you typically put at the top of the pleading?
The Superior Court.
The name of the court in which you're filing and this is called the style of the case. And then you would have a place where a civil action number could be applied, even though you won't know what it is because you haven't filed a lawsuit yet, and that's assigned by the court. What else does a complaint have to have in order to be fundamentally sufficient to get this case going on the last day of the statute of limitations?
A short, plain statement of the cause of action.
A short and plain statement of the cause of action. And that is, in this case, let's just throw something out. Would Deadbeat Dan owes Sally money be sufficient?
No.
Why not? Why would it not be sufficient?
How much?
How's it paid back?
Well, it doesn't state why the money is owed, right? So it would be a whole lot better to say Deadbeat Dan defaulted on a note executed by Deadbeat Dan and has not paid Sally the balance due in a timely manner. That would be a better short, plain statement of the cause of action, right? Because basically what courts want to be able to do is be able to put things in pigeonholes and figure out what kind of case this is. Do you have to attach the note if you do that?
Exhibit. Attach it as an exhibit.
Okay, you can attach it as an exhibit, and we've got an answer here. It would help. Yes, if you want to promote your case, it's good to have an exhibit, but is it mandatory? No, it's not mandatory. And if you do attach the note, Does it become part of the complaint, or is it just like extraneous information?
Part of the complaint.
It becomes part of the complaint under 91110C, I believe it is. Would you want to attach a document, if you're suing on the note, would you want to attach a document, let's say as Exhibit B, which says the note has been paid in full?
No.
No, you wouldn't want to attach that, because anything that's attached to the exhibit becomes a part of the complaint, and that would automatically raise a question of fact as to whether the note was owed or not owed. If the complaint said the note is owed and the attachment said it's been paid in full, one, it would be a false representation of some kind. You'd never want it on there. But I think it's okay if you've got a fraud case, however, to attach a letter where the complaint itself says the misrepresentations made in Exhibit B were as follows, and you attach Exhibit B, because in that instance you would be expressly sort of excluding the contents of Exhibit B as being true. Okay, all right. If you got let's say it's just a one-liner, which was the one that I reformulated. What else do you have to have in the complaint?
Request for relief.
Yeah, you gotta have a request or demand for relief. As my colleague here, Mark, says, you don't want to take a knife to a gunfight. This is a lawsuit, right? We're not just asking for the note to be paid. We're demanding that the court enter a judgment in favor of us, in favor of Saul and Sally on the note. So that is a requirement, express requirement of the complaint, which is under 911 8B, 8-2B, a demand for judgment for the relief that the pleader deems is entitled. Okay, we've got one missing element that's mandatory. Very, very close. An original complaint shall contain facts which the court's venue depends. Under Georgia Constitution, venue is very, very important. And so you would need to state, if you're suing an individual, what regarding that individual? Where they live. And what if it's a street address and you just don't know with absolute certainty where that street address on the street that runs across the county line lands?
I checked with the post office.
Yeah, you would say they live in your county, right? But what if they live in the other county? Is your complaint dead in the water and you get thrown out immediately?
Yes.
You get it transferred to the other county.
Okay, so there are transfer rules regarding if you sue somebody and get them properly served and they happen to be in a different county, then you can end up transferring to another county. And in this instance, you're 3 hours away from the next superior court, although that's unlikely in Georgia. You've got to get it filed in the next 2 hours. And so you can, if you're not sure, you can still sue in the superior court across the street, but you do have to have in your complaint the facts upon which venue rests. And that could be different depending on what kind of suit it is. It might be, if it's an individual, it's the residence of the individual. If it's a company, it could fall under different rules. If it's a tort action, that two people that aren't in the county, it could be a different rule if they're out of state. So, but one way or another, you have to have facts in there that can establish venue. Yes.
So can I know somebody's in Fulton County and file in Cobb and state they're in Fulton and then get a transfer?
You cannot purposefully state anything you believe to be false in the complaint.
So if I believe they're in Fulton, I know I can't file in Cobb because I know it's going to be transferred. I can't file in Cobb.
Well, you can't state that they're in Cobb if you
No, I
know they're in
wouldn't
Fulton. But could you actually file in Cobb? Let's put it this way: I'd rather file in Cobb than file nowhere if it's 459 on the date the statute of limitations run. But you know, it's not preferable, that's for sure. And then you'd have to figure out where it goes from there. But the civil action is apparently commenced under 911-3A by the filing of a complaint with the court. So that might actually solve your statute of limitations problem. And since you're not going to have any other way to solve it, get the case on file. Okay, so we've got the perfect style. We've got Solvent Sally's name spelled perfectly. We've got Deadbeat Dan's name spelled perfectly. We got the facts supporting venue. We got the short and plain statement of the cause of action. We got a demand for relief. Are we running to the courthouse and ready to go?
You need a check.
You need, all right, well,
Release.
with respect to the complaint, do we need anything else?
Request for
Prayer,
relief.
prayer request.
We've already got the demand for, so let me tell you a little vignette. So when I was a brand new lawyer, just like Dan, very first week of my practice, senior partner came in with a complaint, I kid you not, as thick as this book, slams it on my desk and says, does it state a cause of action? And of course, me being the diligent attorney, needing a lot of hours, went to work on it. It had like every imaginable federal statute cited in it. And I went to the library and diligently started working. Meanwhile, my much older colleague who worked for the same guy down the hall had filed a motion to dismiss that he received the assignment at the same time I did, that we won. What basis did he win the motion for to dismiss? The guy had failed to sign the extremely long complaint. You're required to sign your pleadings, and so you have to have your signature on there one way or another. And along with the pleadings, with the signature I'm saying, you have to have certain information that identifies who you are, who's signing the pleading. And it has to be signed by, remember this, paralegals, unless you're pro se, at least one attorney. So we don't want, I would recommend that no matter how much somebody out of the office tries to induce you to sign a complaint on their behalf, don't do it. Get another attorney to come, who's admitted in that court, jump on the pleading, the signs of the pleading. Do not sign a complaint for your attorney, because if it was over, first of all, that could be completely invalid, and also it's just wrong.
Are you saying have another attorney sign with express permission your name? Or you're saying get another attorney to also be counsel on the case so you have one attorney's original signature?
I believe you should have one attorney's original signature. And frankly, I think we ought to have two attorneys on cases anyway. So, well, I've certainly seen one attorney sign with the express permission of another, a complaint. I think it might be subject to a motion to dismiss, because the attorney has to actually sign the complaint based on what the rules say. Well, there's case law out there that says something else. It's just something you don't want to fight over. It's a worthless thing to have to start your lawsuit fighting over whether the complaint is signed or not signed. So just make sure it's signed by an attorney. Okay, I mentioned the rule regarding electronic filing and the authentication of the signatures. That's in Uniform Superior Court Rule 36.16. And this is an opportunity for me to point out another fact you need to worry about. What's wrong with the book I have in my hand? 2016, it's old. I bring this book purposefully so to point out this is not the book you want to read the rules in, because it's old. Not that I haven't updated my discussion since that book came out, but that is, you always want to get the most recent version of the book, or look at it electronically in the most recently updated place on the web or on our electronic services to make sure you have the most current rules. Okay, somebody mentioned a summons. When we first asked, what do you need to start a lawsuit? Do you actually have to have the summons the day you file a lawsuit?
No.
No.
All right. Because under 911-3A, a civil action is commenced when you file the complaint and when you have that civil action case filing. What is a summons? Is it just a funky word used by lawyers so as to exclude people from understanding what the document is?
It's notified.
It's an order of the court, isn't it?
It's, Mr. Meeks says it's an order of the court. Have you read a summons? It says you have been received this document. You are required to answer to and file and serve the plaintiff's attorney within 30 days of service of this document upon you. So it's an order of the court. If you look at the paper that I forwarded, I believe it's on there as an attachment. There's actually a case that probably made one of our colleagues not happy that he became famous. But the style of the case is Stamps versus Bank South, 221 Georgia Appeals 406, 1996. And this is a lawyer who got sued by a bank that he owed money on, and the bank sent him the complaint and said, here's the complaint, and the complaint did not have a summons attached to it. And I believe the complaint was served without the summons, and then a judgment was entered. He appealed and said this lawsuit never was started in the first place because there was no summons. Summons is something that's fundamental to establishing the jurisdiction of the court, and it has to be served upon the defendant. To what is the summons attached, if anything? The complaint. The rules expressly say that the summons must be attached to the complaint. So when you ultimately serve the complaint, you must serve it with a summons if you want it to be effective as far as establishing the jurisdiction of the court over the defendant. And so, generally speaking, the summons is going to be an order issued by the clerk of court with the jurisdiction of the court itself that says the defendant must answer this complaint within the time provided by law, which for all civil people that we're involved with is 30 days after service of the complaint. I think there might be an exception if it's the U.S. government that's being sued. It gives a little more time. But that's what a summons is, and it's a critical portion. It's very easy to fill out, but you have to get it signed. Can you serve a summons that's not executed by the court? No, so you have to have that officially issued by the court. And if you're doing electronic filing, paralegals, how do you get that document?
Sometimes on each court it allows you to generate it itself and have from the appropriate court signed, ready to go.
Okay, does it come back to you after they've already had it, and then the court sends you back?
You get an e-file stamp.
Okay, and so do you have to actually go to the court to get the executed summons? The answer is no, because it comes back to you with the approved electronic signature of the clerk, I guess. Okay. All right, so let's assume, so you got this set of papers. You've got your complaint with the style and all those other things. You've got your attached note, properly redacted for deadbeat Dan's social security number. And you got your summons, and you've got your filled out general civil and domestic relations case filing information. And we've talked to the clerk about the filing fee. And let's assume for the moment it's not electronic filing. How do you actually get this going?
Bring it.
Excuse me?
Sheriff, serve them, process them.
Well, no. Right now you just got the papers.
Gotta go to the clerk's office and get it.
You got to get them to the clerk's office. So do you ask the janitor down the hallway to take them over there for you? We're talking about the last day of the statute of limitations.
I go myself.
You go yourself if you're on the last day, because you want to make darn sure that this is an accomplished task, right? And you really want, before the clerk's office closed, you want stamp filed papers. And so only in the most leisurely circumstances, in my view, should you mail in a complaint and ask it to be returned to you by the clerk. I never want that anyway, because I don't want to think I've got a complaint filed and then find out down the road that I forgot to check that it didn't come back stamp filed. And of course, with electronic filing, you can have concerns over whether you even get a response back during the same day by the clerk's office. So if you really want to be sure, how early do you need to file in a day in order to be sure that the complaint is filed? 10 a.m. or something?
No.
Or even, can you even get them back that fast? I'm
I
sorry?
think it depends on the court.
Okay, depends on the court. But if you're on the, we would all prefer, except for in the circumstance where you're going to make a fortune representing Solvent Sally, that you file many days before the statute of limitations runs, so you can make sure you get that approved filing. Because on occasion you can get a rejected one, right? You check the box wrong or do something wrong on the pull down menu on electronic filing, something can go wrong. Okay, so you run over to the court and you're on the last day of the statute of limitations and you dive across the finish line with your check in hand. The clerk stamps the complaint in, issues the summons. Do you walk, in this instance, over to the sheriff's office? Does anybody know that the sheriff is the one in the Superior Court that does process serving? Okay. Do you walk over to the sheriff's office to have this complaint served?
No, if you have to get it served right away, you might want to get a private process.
Okay. The answer provided to me is no, you don't want the sheriff to do this time around. And why would you worry about the sheriff doing it this time around?
Because you don't know when they're going to actually attempt service. They can't just do it right away.
Right. The sheriff even in a small town, the sheriff might have a stack of complaints. And what happens if your service is not timely on this particular case where the statute of limitations will have run? You can end up losing the case for failure to prosecute it timely if the process service is a problematic situation. So in some courts, however, you have to do a little bit of preliminary work in order to get a private process server on board. There are certain process servers that are certified and are available for service, but not necessarily in every superior court. And has anybody ever had a superior court say, I won't appoint the process server unless the sheriff has had an option to do this? We have some nodding back here. Yes, some courts are very provincial and they don't want to appoint process servers unless the sheriff has already made an attempt to serve. How would you go about getting a private process server in place to serve Deadbeat Dan? Hopefully tomorrow.
Like court order.
All right, in order to get a court order, you've got to have a motion. So, first order of business, of course, is getting this complaint actually filed. If you need to get a motion together and a proposed order for the appointment of a process server, you can do that tomorrow. But what's the advantage of a private process server attempting to serve Deadbeat Dan for you in this case?
They usually will make more attempts. Sometimes the sheriff will go out once or twice and say, couldn't serve them, and they'll send it back non-served.
Okay, so one answer is the sheriffs will often try once or twice and then send you what's called a non-est, which is another way of saying we didn't get them. And then you find out down the road that you didn't succeed in service. Does the sheriff report back to you every time they make an attempt? No. Can you get a private process server to report back to you regarding the effort?
Yeah.
Yes.
Can you get a private process server to basically log in all the efforts to serve the defendant.
Yes.
Yes, and so if you got a statute of limitations that's already run, it's the burden on the plaintiff to show the court ultimately that there was reasons for delay in service of process if the statute of limitations defense is raised by the defendant. And so you want to be able to have evidence to be able to show that you use due diligence in getting the defendant served. And the only way I know of to do that effectively, unless the sheriff is, your best friend or something, is to get a private processor to do it. Okay, so let's assume that the other thing is, in this instance, what happens to the sheriff if you do ask the sheriff to serve it? Let's say it's the best sheriff in the world. You've known him your entire life, and he's going to serve it before Friday Night Lights starts at the high school football game. You give him the summons attached to the complaint, and the sheriff heads out to serve Deadbeat Dan. And Deadbeat Dan lives just over the county line. The sheriff pretty much, and if that's the line, the sheriff doesn't go over the line and won't serve Deadbeat Dan. And then you have to start all over again. So to get insurance against not getting Dan served, it's maybe a good idea to have a private process server. I will also say I had a private process server who served a complaint. The complaint basically was, make it real simple, that my client's business was stolen by somebody they had hired to do a website. It was a website-based business. The person who was supposed to build the website actually stole the business of the plaintiff. And the private process server, when they appeared, served the complaint. For whatever crazy reason, the defendant gave the private process server a tour of the business. Walked them through the inventory, showed they were trying to persuade the process server they really hadn't made any money doing the business by showing how much inventory they still had left. Well, we got a frivolous litigation letter from the defendant's lawyer saying they'd never had a business. This was totally frivolous. There was no business existed. No business had ever been started by the defendant. And we were able to get the private process server to provide an affidavit saying, well, the lady gave me a tour of the business and showed me the inventory. So I put an end to that. So you can get information back that's legit, from the private process server. So if Dan is served with the complaint and the summons, are you good to go? Let's take a vote. Are you good to go if Dan is served?
Yes.
Because you have to file an affidavit of service.
Oh, yeah, that's right.
Oh, so you actually have to prove to the court that Dan has been served.
Yes.
And so how do you go about doing that? If you get the sheriff to do it, what do?
They'll send you a sheriff's entry of service, and you take that and you file that with the court, or if it's a process server, it will be an affidavit of service, which will list exactly who they served, when they served, they sign it off, and then you file it with the court.
Okay, so sheriff does it. It's a sheriff's return of service, filed with the court in the same civil action where you just started your case. And if private processor server does it, it's an affidavit. And they say who, when, where, how, etc. So you can identify that person. And I hope, you pray that the person they say they've served is the same person as Deadbeat Dan, not the minor child of Deadbeat Dan, not the uncle, but actually Deadbeat Dan. So I think we got our lawsuit started. Next time we'll talk about initial discovery considerations, things if you have a little more time that you have the opportunity to put together some discovery to get your lawsuit started and what you should consider when doing that. How you can strategically bring the gun to the knife fight if you want to collect sooner rather than later. And thank you so much for your participation. And we
I
have
just
one
want to
more.
clarify for the record that we've been talking about state court procedures and federal court procedures are very different.
Yes, so
Can be.
for the record, yes, We are concentrating solely on the Civil Practice Act and the Uniform Superior Court and/or state court rules, depending on which court you're in. And federal court is a different ball of wax in many respects. So don't think you can go down to federal court and start an action the exact same way you started what we discussed today. We'll cover that in the good fullness of time. Thank you for being here.